Good afternoon, good morning, everyone, and welcome to the second webinar of the Digital Dialogue series on the progress and challenges of national efforts to address impunity for sexual violence in conflict. We're extremely happy to have you all with us today. My name is Muna Rishmawi. I am the Chief of the Rule of Law, Equality and Non-Discrimination Branch at the Office of the High Commissioner for Human Rights. Our office is one of the co-lead entities of the teams of experts on rule of law and sexual violence in conflict. As you may have seen, as you may know, the Journal of International Criminal Justice has devoted a special issue on domestic accountability for conflict-related sexual violence. Through this series of webinars, the teams of experts, in collaboration with our partners that I will name shortly in this seminar or this webinar, we all seek to explore some of the themes highlighted in this special issue, in particular with regard to the strategies and lessons learned regarding advancing national efforts to end impunity and advance accountability for sexual violence crimes. The first seminar or webinar, I keep saying seminar, is actually a webinar of the Digital Dialogue series, took place in July, and the special representative of the Secretary General herself, Madam Pamela Pattern, has actually launched the special issue, and this was really to mark the beginning, the start of these webinars. Today, we'll be focusing on Latin America, and we will discuss some Latin American experience, in particular, the experiences in Colombia and Guatemala. There, while impunity for serious human rights violations and international crimes have actually, including sexual violence, have lasted for a very long time, we are recently starting to see some glimpses of hope. And we can point out today to some of the progress in advancing access to justice and accountability with regard to sexual violence. To do this with us today, we have a panel of really remarkable women who were at the core of this work. I have three panelists, Daniela Gravitz, Susanna Sacuto, and Maria Valinas and Anna Medina. They have been at the heart of nudging the progress forward, making concrete contributions to advancing the fight against impunity for conflict-related sexual violence crimes in Latin America. We are also very pleased to have with us Ambassador Charlotta Schlitter of Sweden, who will deliver concluding remarks. Thank you all for being with us, and I will start the discussion. We'll try to be as interactive as possible. But before I do and I start the discussion, I would like to tell our audience that you have the possibility to send us and post questions to us and to the panel on the YouTube chat. We will do our best to pose the questions to the panelists, no promises, but we will do our best during the Q&A segment of the webinar. In addition to the questions, we have questions that were sent to us. Our first panelist is Daniela Gravitz. Daniela is an international lawyer from Chile with extensive experience in human rights and criminal justice. After working at the UN International Criminal Tribunal for former Yugoslavia, she served on the panel of experts on Sudan and is currently the UN Special Rapporteur on the situation of human rights in Eritrea. As you can see, her work extends globally, and she has focused on these issues including on providing technical assistance and training to domestic institutions on women's rights and on addressing gender-based violence. She has a very interesting article in the special issue, and I would like to ask her in particular. I'd like to ask you, in particular, Daniela, if you can pause a bit and tell us about the evolution of the strategies regarding applying international criminal law framework to bringing accountability for sexual violence. You really have made some very interesting observations in your article. I would like in particular to seek your thoughts on what were the key building blocks in delivering justice to the victims of sexual violence, particularly in the two countries, but perhaps broader.
Thank you so much, Mona, for that introduction, and good afternoon to those of you in Europe, and good morning to those of you on the other side of the ocean. It's my pleasure to be with you here today and to be participating, and I really look forward to our discussion. Now, diving right into
Are you there with us? You seem to have a bit of a connection problem. Maybe we hear Daniela in a minute, but maybe I'll go to Susanna and ask Susanna to. Sorry, Daniela is back.
I'm really sorry. I seem to have been kicked out of the chat and just when I was getting started. These are the realities we're dealing with these days when we're meeting virtually. So I hope not to be able to very quickly get through my point. So I'm going to be speaking about legal development specifically. And one of the first main developments that we've seen from national systems is the growing recognition of sexual violence crimes and other forms of gender-based violence as core international crimes, that is, as war crimes, as crimes against humanity, and specifically in the context of Guatemala, as underlying acts of genocide. And this is significant because it has places crimes on the same level as other serious violations that are before national jurisdictions, such as murder, enforced disappearance, and torture. And it has also helped us to understand the different manifestations of this violence in context of mass atrocities, and to better comprehend the long-lasting impacts on the victims, their families, and the broader communities. But a very important aspect of this recognition is that it has helped to dispel the notion that these crimes are somehow incidental, collateral, or are the result of private acts by rogue individuals. And I wanted to give you two concrete examples, one from Argentina and one from Guatemala, of how domestic jurisdictions are recognizing the gravity of these crimes. In relation to Argentina, there have been prosecutions of dictatorship abuses, and courts in Argentina have focused specifically on sexual abuse against political prisoners in clandestine detention centers. And the courts have found that these crimes formed an integral part of the repression. And what's really interesting is that they've labeled these crimes as forms of state terror, so terror that has been launched by the state against its own citizens. In the case of Guatemala, there have been 2 genocide cases that have been completed and 2 that are currently ongoing in the pre-trial phase. And those cases the completed cases have focused on the use of racialized gender violence in particular against women from indigenous communities. And what's interesting there is when examining the requirements of genocide, specifically intent, the court in both completed cases found that sexual violence crimes against women was objective proof that the community as a whole was being targeted. So this is again an example of how the gravity that's been attached to these crimes before national courts. And beyond that, what we're seeing is a growing tendency to use broader definitions of sexual violence crimes. So beyond rape to include sexual slavery. And I know my colleagues will be speaking about Sepur Zarco later, and also forced nudity in some contexts. And we have seen, I would call them some timid attempts to begin to also focus on violations against the reproductive rights, in particular of women. And we're seeing that currently in the context of Colombia, for example, with the focus on forced contraception and forced abortion within the ranks of some rebel groups. And what we're also seeing is a more consistent application of international standards on issues such as the assessment of victim evidence, on corroboration in the sense of not requiring corroboration, and also the assessment of the trauma of victims and the possibility of victims of recollecting all the details of events so much time after the event. And this is largely due to the influence of the jurisprudence of the Inter-American Court of Human Rights that has developed standards on all of these issues, but also on the fact that courts in the Latin American region are progressively incorporating also the standards of international courts and tribunals such as the ICTY and ICTR and ICC. Last point I want to make concerns the attribution of responsibility. And what is important here is that the courts in the region are recognizing the responsibility not only of those who physically committed the crimes, but also of those who orchestrated and enabled campaigns of mass violence. And so what is important about this specific factor is that legal practitioners are moving away from this notion that only physical perpetrators can be held accountable and are focusing more on constructing cases that document the factors that facilitated the crimes. And very small point on proof of intent in cases of high-level leaders who did not commit the crimes themselves and were not present at the scene of the crime, is that we're seeing a growing tendency to consider that it's sufficient to establish that those in leadership positions were aware of the conditions that facilitated and contributed to placing the victims in a situation that exposed them to sexual abuse, and that tolerating and accepting that sexual violence crimes were likely in such contexts is sufficient to hold them accountable. And this is, for example, in the context of prison settings or campaigns of mass violence, attacks on villages, forcible displacement. I'm going to stop there. I'm sure I've gone over the time. And I'll be happy to answer questions later.
Thank you very much for this really important overview that shows really the evolution. But I like very much that you focus that on the victimization of not only the individual, but also communities, and also the responsibility of not only the person who did the actual conduct, rape or sexual violence, but those who are behind it, which I think is really important to get to the bottom of this, these kind of international crimes and how the international criminal justice system have evolved to basically take care of or to take into account these incredibly important but also complex dimensions. So we'll move on, and I think our next speaker, I think, will be able to also dig deeper into some of these issues. Our next speaker is Susanna Sakoto. Susanna directs the War Crimes Research Office at the American University in Washington College of Law. She's also a lecturer in residence there. She has worked extensively with the tribunals and with advocacy organizations at the domestic and international levels. She also co-directed the Academy on Human Rights and Humanitarian Law on a project entitled Ending Impunity for Conflict-Related Sexual and Gender-Based Violence in Latin America. and engaged in really many countries and in many cases in countries such as Peru, El Salvador, Venezuela, Mexico, and Guatemala. But I'm going to ask her today on a particular case that actually was mentioned by Daniela, where we think a lot of advances were made in this case. The case is of Sepur Zarco. Sepur Zarco. I don't speak Spanish, so maybe my pronunciation is not good. You wrote about this case, Susanna, in the special issue, and you were personally involved in developing the strategy around it. This is a landmark case in terms of advancing accountability for sexual violence crimes, and particularly sexual slavery, through the prosecution of 2 former military members. I'd like to ask you in particular about it's considered as a success case, as an important case, as a landmark case. To you, what were the factors were essential for attaining the results? And could you please highlight, in particular, the central role of victims and, if possible, support groups in this case?
Thank you so much, Mona, and many thanks to the organizers for the invitation to be with you here today, to my fellow panelists and to our audience out there. Let me start out by saying that although I've been asked to focus on the strategies used in the Sepur Zarco case, and not particularly on the role of civil society actors or victims groups, which I think my co-panelist Ana Medina will address, this case, frankly, would never have gotten off the ground if it were not for the persistent, dedicated, passionate, and frankly, brilliant work of Ana Medina, Paula Barrios, and her other colleagues at Mujeres Transformando el Mundo, as well as other civil society groups who work tirelessly to assist and represent the victims, or the abuelas, the grandmothers, as they are known in this case. So although I'm going to focus on legal strategies, one very clear takeaway from this case that was indispensable, in my view, to its success was that the victims and their representatives remained central actors throughout the case. But I've been asked to talk a little bit about strategy. So I'm going to spend the little time I have with you on some of the unique and innovative advocacy and legal strategies that contributed to the success of the case. And although there's a lot to talk about, I'm going to focus my remarks on just a few strategies that I think were crucial and demonstrate the critical role of victims and their representatives in the case. So one was the groundbreaking strategy to charge sexual violence as an international crime, like Daniela spoke about, but within the using the Guatemalan Criminal Code. 2 were the efforts taken to protect victims and to avoid their re-traumatization. And 3 was the extensive use of domestic and international experts at trial. I don't think I have time to cover, I really wanted to talk about reparations, but I think Ana Medina will do that as well. So if there's time, if not, we'll hopefully get to that in the Q&A. So let me start with the charges. The accused in Sepur Zarco were charged with sexual violence, among other crimes, sexual violence and sexual and domestic slavery under Article 378 of the Guatemalan Criminal Code, a provision that's entitled Crimes Against the Duties of Humanity. So while the accused could have been charged with rape or other forms of sexual violence as ordinary domestic crimes, prosecuting them as individual isolated acts would have missed the context in which they were committed, namely that they were part of this military strategic plan to punish the men of this town, Sepur Zarco, for their attempt to protect their lands and to instill fear in their community, which was in turn part of a broader military plan to defeat those they perceived as insurgents. The victims and the representatives were clear that they wanted to make this context visible and pushed for the characterization of the sexual and gender-based violence as crimes against the duties of humanity. Now, what's interesting is the public prosecutor was initially reluctant to pursue this approach. And I would say with good reason, right? In 2011, when the abuelas filed their complaint, nearly all of the successful prosecutions for crimes related to the conflict had proceeded as ordinary domestic crimes rather than international crimes. Only a handful of complaints had been filed under Article 378, but most had not yet proceeded to trial. So it was new territory. But through the persistent advocacy of victims' representatives, along with some external support, by the time the final indictment comes out in 2014, the prosecution was firmly committed to prosecuting the accused for crimes against the duties of humanity. Of course, that was not the only challenge. Another problem was this incorporation of international law, right? Article 378 referred to violations of international humanitarian law, certain acts committed against the civilian population, but it did not list the specific sexual and gender-based crimes the victims were alleging. Fortunately, we had a very astute, progressive first instance judge that interpreted Article 378 as permitting the court to adjudicate acts constituting crimes under customary international law binding on Guatemala at the time the acts occurred, which in turn permitted him to charge the accused with crimes against the duties of humanity in the forms of sexual violence and sexual and domestic slavery, all of which were arguably constituted war crimes and crimes against humanity at the time they occurred. Now, why was that significant? I think Danielle alluded to this a bit in her remarks. It was significant for a number of reasons. First, it reinforced the systematic nature of the sexual violence against the victims, making clear that those acts, the acts committed against them, were not isolated acts or the product of, say, some rogue soldiers, but rather a part of a broader counterinsurgency military plan. Second, it made clear that the circumstances in which the acts occurred were coercive, and that in those circumstances, genuine voluntary consent of the victims was highly unlikely, if not impossible. And that was important because it allowed the victims who had been stigmatized and even frankly blamed for the abuses they endured to shift that blame to the perpetrators, helping them to heal from the stigma and isolation that they experienced and to regain some of their dignity within their community. Finally, it challenged this prevailing narrative about sexual violence in Guatemala's conflict, which had been largely, frankly, invisible until the Sepur Zarco case. The second strategy I want to touch on were the efforts to avoid re-traumatization of the abuelas. During the trial, the court heard from over 70 witnesses. The vast majority of those witnesses testified in person at trial, but the abuelas testified via pre-recorded testimony that had been taken during the preliminary investigation. Although the victims, actually, the abuelas, they were present at trial. When you see pictures of the trial, you'll see them in the courtroom. But their representatives indicated to the court that requiring them to testify again in court would negatively affect their physical and mental well-being. And expert testimony was presented at trial that established the victims were in fact suffering from PTSD, and the re-traumatization could occur through the repeated telling of their stories. Although the defense objected vigorously, as you might expect, the court admitted the pre-recorded evidence on the basis that the testimony had been properly taken in compliance with the requirements of Guatemalan law, including the appointment of a public defender who was entitled to cross-examine the victims during their pre-trial testimony. Now, the decision was significant because in the context of a case brought to trial decades after the crimes were committed, and where physical evidence of the crimes was limited, the victim's testimony was crucial. It was a critical part of the evidence against the accused. But without the trial court's decision, allowing it to rely on the pre-recorded testimony, that effort to seek justice on behalf of the victims may have resulted in further harming those very same victims. You know, I've gotten a time notice. So I'm going to say a few words about the third issue I wanted to highlight and then save the rest of the discussion for Q&A. Another significant aspect of the trial was the fact that in addition to the live and prior recorded testimony, oral testimony was provided by 24 expert witnesses. The comprehensive nature of the expert testimony in the case undeniably bolstered the credibility of the victims. That expert testimony allowed the court to kind of stitch together the various pieces of evidence into a whole and into experiences and to understand the experiences recounted by the victims. And I'll just give you one example and then I'll end there. There was a gender anthropologist named Rita Laura Segato who provided critical insight into the Mayan culture of women in their communities and how each of those had been deeply affected by the crimes. She helped the court understand, for instance, that the gendered domestic labor that the victims were forced to perform in the form of cooking and washing for the soldiers caused them significant harm, equivalent actually to them to the harm caused by sexual slavery. As she explained, in the view of women, of the victims and their communities, the inability to provide for their families because they had been forced to abandon their children and use their own corn to cook for the soldiers, even as their own children went hungry, caused them intense shame and guilt and deeply undermined their position within their community. That helped the court understand that the crime of domestic slavery, which might be viewed by some, frankly, as less serious than sexual slavery, represented an equally grave crime to the victims. Unfortunately, I don't have time to share other examples, but suffice it to say that I think the expert testimony was indispensable in helping the court not only better understand the victim's testimony and give it appropriate weight, but also to appreciate the crimes, how the crimes committed against them fit within that broader context of the armed conflict and the role the accused played in the commission of those crimes. I'll stop there because I think I probably ran over a minute or so. Happy to take questions and look forward to the discussion.
Thank you so much. Thank you, Susanna. I mean, what you presented is extremely rich in terms of the elements that led to this success. And I was actually quite taken by what you said about the judge who actually took a leap of faith, so to speak, and interpreted the law in a progressive way. And that's actually a lesson to a lot of judges today, to see how, with one judgment, you can actually you impact the fate of a lot of people. But the real people behind this case, of course, are the judges, the lawyers, the prosecutors. The real people behind this case are actually the victims. And here, we're so privileged to have with us Anna Medina. You mentioned her, Susanna, and you mentioned that she actually was one of the main actors in the Sepur Zarco case. Anna works for an organization, an NGO in Guatemala, Mujeres Transfer del Mundo, Women Transforming the World. I love that title. Thank you for choosing that title. It's a Guatemalan NGO that was really instrumental in the case that you mentioned. So it would be really, it's very important to hear from you, Anna, and I would like to hear from you in particular about this journey, or this journey that you went through. For you, most probably, this was not just a trial, it was a 20-year process. Can you tell us something about that? And can you tell us how people looked at it, particularly in terms of, was it seen only as a, or was it seen as a conviction in court, or there was other elements to it that perhaps could bring it closer? I don't want to call it holistic justice, but something closer that could bring some relief to the victims in this case.
Good morning or good afternoon. It's a pleasure for me to be here and explain a little bit about the process of Sepur Zarco case. As Susanna said, the women were always in the court and hearing the procedure when it was taking place. But before this work, before this process, the organizations of the social society have a big importance, because, for example, before all this happens, before the sentence, before the court, before everything, in 2009, three organizations of the civil society organizations came together and create the alliance. One alliance that wanted to show what happened during the conflict in Guatemala, because during this time, a lot of women were, as Susanna said, received a lot of violence, sexual violence, domestic violence, and it was so important that someone showed and someone explained and someone present to this woman and looking for justice for the woman. And that's why the three organizations create the Alliance Breaking the Silence and Impunity with the objective of accompanying women, mainly indigenous, that were victims of sexual violence during the internal conflict armed in Guatemala. The alliance was up by three organizations: Mujeres Transformando el Mundo, this is the organization that I represent today, and the Community Studies and Psychosocial Action Team, and the National Union of Guatemalan Women. From the beginning, the Alliance had the support and worked very closely with women organizations and human rights organizations that promoted the initial process to break the silence for sexual violence. This is very important because, as I told you, the woman didn't want to say what happened to them during the armed conflict in Guatemala. They had the whole things to themselves. And it was so difficult for them because during a lot of years, they can talk, they didn't say anything to their families because they don't want it to be stigmatized, because they were going to receive, they didn't know how the community or their own family were going to receive what happened to them. They believed that they were guilty for the things that happened to them, and it was not true. They wanted, they believed that they do something because this kind of thing happened to them. And as Susana said, it was something that the military did because they wanted to don't let them to obtain the land of Sepur Zarco farm. And this is the beginning of the conflict in that area. And these three organizations create this alliance to help that woman. They create this alliance to help them to believe in themselves, and that because they wanted that they say what happened to them, that they look for justice, that they obtain justice, that they continue their lives without guilty, that they showed what happened, and the other women that suffer the same things come to the judicial tribunal and say what happened to them too. Because Sepur Zarco case is not the unique case. There are a lot of cases, there are a lot of women that happen the same thing that the women of the Sepur Zarco case suffer during this conflict. The first activity that this alliance prepared was a tribunal conscience against, and they wanted that the women see how was a judicial process. They explain them, they present the way that could be they act when if they decided to present their case to the justice of Guatemala. And it was very important for them. The organizations help them to be empowerment. The organizations help them to decide to say what happened to them. And for example, they give them the whole possibilities of tell what happened to them. They give them accompaniment, psychosocial, political, legal. For example, MTM has the strategic litigation of this case, and we were working with the woman explaining everything, because they need to be prepared, because they were going to hear a lot of bad things in that court. But they also had the help or the accompaniment on other persons. I don't know, Susana maybe could see, but in the court were a lot of people given tell them that they were with them, and it was so important. The most important thing of this alliance is that without this alliance, maybe this sentence could be happen. Maybe if the institutions, the organizations didn't decided to be together, the women never talk, never say the things that they suffer, and maybe this case didn't exist, and this important sentence couldn't exist in Guatemala because this is the first sentence about transitional violence is in the court. And I believe that it's very important, the job that the organizations made, the help that they give to the woman, because always the organizations said that the women were in the center. Always the women were present in all process. Thank you very much. I would like to explain more, but my time is over. Thank you.
Thank you, really thank you. I mean, the courage of the women and the courage of your organization to encourage the women to break the silence, to empower them to come forward, and the support that you have given to this woman is incredibly remarkable. So it's all of us as international lawyers who have to thank you for really breaking not only the silence of these women, but also breaking years of judicial practice and giving us such an important jurisprudence I think for women in many, many countries that will be extremely useful. To move on, we have our next panelist is Marta Valinas. Marta is well known in my quarters. She's currently the chair of the fact-finding mission on Venezuela established by the UN Human Rights Council. But she is a lot more than that. She has very vast experience in criminal justice, and she has worked with the ICC, with several organizations in the field, and also did a lot of work with professionals in domestic jurisdictions in Guatemala and Colombia, which we are focusing on today. Her article is extremely interesting about the newly established Colombian Special Jurisdiction for Peace that we keep hearing about, which started to work in 2018. Her article gives us a bit of a glimpse about how the elements and the considerations that this, what we call SJP, the Special Jurisdiction for Peace in Colombia, what are the elements that they need to take into account in addressing sexual violence, how they can benefit from all the experiences or past experiences, and some of the key challenges that we might anticipate in this and how to overcome them. So over to you, Marta, for some reflections on these issues. Unmute, please.
Sorry about that. Thank you, Mona. The Colombian Special Jurisdiction for Peace, or SJP, as you said, was created with the explicit aim to place victims at the center of the justice process and to apply restorative justice as a guiding paradigm. So actually, as a judicial body, it's quite innovative. Maybe for those of you who are not so familiar with it, this jurisdiction has the possibility of applying sanctions to the perpetrators of serious crimes related to the conflict, provided that they offer full truth, reparation to the victims, and guarantees of non-repetition. But while the structures of the SJP the structure is novel in many ways, it has definitely benefited from various lessons learned in the region and beyond, including those mentioned before by the other panelists. So for example, the possibility of using the international legal framework on war crimes, crimes against humanity, to legally characterize different acts of sexual and gender-based violence is perfectly made clear by the SJP's normative framework. And in fact, this is a path that had already been charted, for example, by the 2014 law on access to justice for victims of sexual violence, which, by the way, incorporated some suggestions made by the team of experts. Also, evidentiary standards in cases of sexual violence that have been consolidated in the Rome Statute of the ICC were also incorporated into the SJP's statutory law. So one of the novelties of the SJP are the different ways in which victims and affected communities participate in the proceedings. The jurisdiction placed special emphasis on hearing the victims' accounts of what happened to them, but also of the harm they suffered at the beginning of the process. The Chamber for the Acknowledgement of Truth and Responsibility is considered the entry point to the truth of the victims through particularly collective reports that the Chamber will take into account and use to assess whether the accounts that it receives from the alleged perpetrators are truthful and are complete, and whether they are acknowledging full responsibility for their actions or not. So, although the Chamber will take into account other sources of information, such as official reports by public institutions, the role of civil society organizations, which has also been mentioned by other panelists, has been key also in this process. So far, the jurisdiction has received a bit over 30 reports, specifically on acts of sexual and gender-based violence. Now, one challenge that I see with this approach are the limitations that unintentionally this approach creates in relation to which truth or which fraction of the truth of the victims will be taken into account. And for this reason, it seems to me that it is important that this chamber in particular has a proactive role in reaching out to gather accounts of victims and affected communities who may not be so well organized or so inclined to put their narratives into a written report, particularly narratives of sexual violence. As well as, I think it's important for the Chamber to give opportunities to those who have submitted reports to expand on the information they submitted in writing. And perhaps more challenging, I think the Chamber needs to create a space for the multifaceted experiences of certain victims to be conveyed, some of whom may not even identify primarily as victims themselves. And I'm thinking in particular of the female former members of the FARC. I have to note that the jurisdiction has already engaged with affected communities in their territories in several occasions. And I have to note in particular the commendable effort of magistrates of this chamber, the Chamber for Acknowledgement of Truth, who have organized hearings with communities, both for obtaining more information from victims who submitted collective reports, but also on measures for reparation and other views they may have. I think that the outreach and dialogue that the jurisdiction will maintain with individual victims and affected communities and the organizations that represent some of them will be largely determinant of the overall success of the jurisdiction. So it is important to keep this dialogue open. And I believe that, this effort by magistrates that I mentioned, which is not something that we see, it's not so commonly seen in other jurisdictions, may actually prove to be one of the greatest strengths of this jurisdiction. I think the outreach to the communities will also be important in other ways. For example, also in addressing male sexual violence, which has not been brought so much to light in the reports that have been submitted, except when this violence has been committed on grounds of gender orientation, sexual orientation or gender identity. Now, the last point I wanted to make is that the importance of contextualization of sexual violence acts, which has also been alluded to by the other panelists, is key. And we see the risk of decontextualizing sexual violence in some decisions, one of which I explain in more length in my article, in which the acts of sexual violence were still seen as not connected to the conflict because the perpetrator committed them to obtain a mere personal satisfaction. So definitely there is work still to be done. Part of it is really still working on analyzing properly the information and contextualizing the sexual violence acts in an appropriate manner. I think we'll be able to still discuss some of these issues and others related to this fascinating jurisdiction in Colombia, and I'm happy to receive your questions. Thank you.
Thank you very much. This is really a very, very rich and very important, actually, intervention, because for many people, this jurisdiction, this new jurisdiction is actually, I wouldn't say a model, but I mean, to be a model, we'll have to wait and see what it will actually do. But at this stage, I think people are looking at it very, very carefully and very closely. So as a result, we received a number of questions from the chat and from actually before the meeting, in advance of the meeting. And I would like to basically separate them from some questions dealing with Colombia, some questions dealing with Guatemala. I'll start with the questions on Colombia. And actually, it is about the jurisdiction, the special jurisdiction. So the traditional or the very common question with all the transitional justice mechanisms is basically most of the sexual violence crimes or conflict-related crimes are given to the transitional justice mechanism. Is there a role for the ordinary courts? So I'll start with that, but maybe I can combine it with the two other questions on Colombia, because maybe I can give you, Marta, the floor, and then give Daniela the floor to look at these two issues. And then we go to Guatemala. The other question is about how much, and you already alluded to that, Marta, how much the cases right now before the special jurisdiction actually deal with sexual violence crimes. And in your opinion, what would be the element to make them succeed? My understanding is that there are 7 cases right now, or one of the chat questions says that there are 7 cases right now that are mostly focused on child recruitment and about, so it doesn't seem to be focusing exclusively on sexual violence. How can we bring the sexual violence element to these jurisdictions? Maybe Marta and then Daniela can take the floor on these issues.
Yes, thank you for the question, which is really interesting, whether transitional justice mechanisms can deal with all the sexual violence cases. Well, you know, according to the National Center for Historic Memory of Colombia, there are more than 15,500 victims of sexual violence related to the conflict, which is really a lot. We're speaking about a conflict of, you know, over 50 years. So I think the effort needs to be a collective effort from different jurisdictions. I have to point out that the special jurisdiction for peace has prevalence in the adjudication of cases that fall under its jurisdiction, that is, crimes that have been committed before the 1st of December 2016, and committed by those that have signed the agreement. So the FARC on the one hand, and state security agents. But you know, what is interesting is that, as I said, the procedures in this jurisdiction are based on, you know, an acknowledgement of full truth and responsibility. But even when the individuals do not acknowledge full truth or responsibility, their cases will still be dealt with by this jurisdiction. And in that case, the unit for investigation and prosecution will act as a prosecutorial body, and the procedure that will be followed is an adversarial procedure. And so, you know, the special jurisdiction for peace is actually quite a key actor nowadays in bringing accountability and justice to the victims of sexual violence. I think I'll hand over to Daniela, and then I'll go back to your second question. Is that how we should proceed?
Yes, but maybe we can be brief, because I think we are running out of time a bit.
Okay, so I'll turn to the second aspect of your question that has to do with the role of ordinary courts. And you asked, Mona, if they have a role, and I think yes, definitely. Up until now, there have been few cases prosecuted before ordinary courts, and these have mainly concerned cases where the perpetrators or the accused did not meet the requirements to be tried within the transitional justice framework. And a concrete example is a case that I can give you from the Justice and Peace jurisdiction, is a case concerning a military commander known as Marco Tulio Perez Guzman, who had submitted himself to being tried before the transitional justice system of justice and peace, which requires accused to admit to the crimes in exchange for a reduced sentence. But when confronted with crimes of rape and sexual slavery against women in the territory that he had controlled, he refused to admit to those crimes and said that the victims were merely his girlfriends. So the chamber did not accept that, and in 2015 excluded him, and his case went to the ordinary justice system. And in 2018, he was convicted for crimes against humanity before an ordinary court in Sincelejo. And that case also was expanded, so it included also some of his subordinates who had aided and abetted in the crimes, for example, by capturing the victims and taking them to the base where he was raping them. So that's a concrete example of where the ordinary justice system has played a role, and the subordinates were also convicted. And just so you know, this is a case that you're probably familiar with. It's been featured in the documentary The Prosecutors by Leslie Thomas that I'm sure you're familiar with. One aspect, though, about ordinary cases, ordinary courts being involved in these cases is that sometimes they may not have necessarily the best setup and technical expertise to handle complex cases involving war crimes and crimes against humanity. And oftentimes as well, it may be dangerous for the victims and also for those involved in the justice process to have the case tried locally, close to where the events occurred. So having these specialized courts removed from the actual area where crimes are committed can actually be beneficial. And one last point, because I see I'm running out of time, is also, as Marta said, that the HEP, the Special Jurisdiction for Peace, has a mandate up until December 2016. But the fact that the peace agreements were signed doesn't mean that the violence has stopped. If for anyone who's been following the situation in Colombia, there are still high numbers of killings of human rights defenders. Violence against women is rampant. And you see many of the same groups or splinter groups that have returned to the communities and that are back at committing acts of violence against the civilian population. So I think ordinary courts also have a role in tackling that we can call it current day violence. And this is a question I leave open, that it's really hard to know if this is violence that we can consider conflict related or not. The conflict has officially ended, but the root causes of this violence, the actors, the victims, the methods applied are the same as those that we've seen in the past. So I think courts, ordinary courts definitely have a role to play, but I leave the question open if this is something also for the special jurisdiction to address. Thank you.
Thank you. Susanna, would you like to say something right now? Sorry, Marta, we go first to you, Marta, and then we go to Guatemala, sorry.
Okay, thank you. Yes, on the question of, which cases currently open by the Special Jurisdiction for Peace deal with sexual and gender-based violence, actually, more than one of the 7 ongoing cases are looking into acts of sexual and gender-based violence. Case 7, which pertains to child recruitment, is indeed one of them, but others, so-called territorial or actually regional cases, are also looking into these acts. And I think they will be very important in showing how sexual and gender-based violence is connected to other crimes and to the overall policies and practices of the different actors in the conflict, which the other panelists, highlighted the importance of establishing these connections and showing how individual acts are part of that broader, context. There have been public calls from civil society organizations for the jurisdiction to open one or more cases focused specifically on sexual violence. And in my view, these calls are not mutually exclusive to continuing to investigate and analyze sexual violence as part of the other regional cases that I mentioned. But yes, it's true. I think cases specifically focused on sexual violence can be important. As Susanna mentioned in her article, they not only give more prominence to the topic, but they also allow for certain solutions, for example, of an evidentiary nature to be adopted, which are better suited for victims and witnesses of sexual violence. So, and we know that thematic cases of sexual violence have been important in also international jurisdictions. Now, we will have to wait and see if such a case is opened by the special jurisdiction. And interestingly as well, we'll wait to see what is the degree of acknowledgement of truth and of responsibility by the perpetrators of sexual violence acts. Thank you.
Thank you. Thank you very much. Let me now go a bit to the Guatemala experience. I'd like to ask you, Anna, first. The experience in the implementation of the Sepur Zarco judgment, particularly with regard to reparations. If you can tell us where do we stand on that, that would be extremely helpful. Thank you very much.
Okay, thank you. Then of the sentence where happened, MTM decided to move, for say something, the 16 reparation measures. I couldn't tell before, but the Sepur Zarco case has 16 reparation measures that takes themes like education, culture, land, that this is the most important, the land, because without land, we don't have anything here. And MTM promoted a monetary plan. And the first thing that we do, like organization, was informed to the state of Guatemala, because they didn't know that they have responsibilities in this case. The executive organism didn't know about it. They didn't know that they have to responsibility in this case, and that they have to make actions to realize the Sepur Zarco case sentence. And the first thing that we did was explain them about the case. We made meetings, we sent information, we create information, because they didn't know where Sepur Zarco was. They didn't know about the case. They didn't know about the grandmothers, the abuelas, as Susana said. They didn't know anything. And the executive branch has a lot of responsibility in this case. And this is the first thing that we did. First of all, send them information, then explain them, then make an information for them, because we need to explain them what was going there to do, because they didn't know anything. Then we open an interinstitutional space. And in that space, we make meetings, 4 meetings a year, because we are making these meetings since 2016. And in that meetings assist the representatives of the institutions of the executive branch of Guatemala, and they know about the reparation. They are making some challenges in their own operative plans of work. And this is, for example, the strategy that the organization decided to do. We have advances, we have challenges, we have a lot of things, because the way of reparation is not easy. It's not easy because the state don't want to do that. They think that this is not their responsibility of them. They believe that if someone should do something, that this person responds for the things that he did, for example. But in this case, the state understood at last understood that they have a responsibility, and now they are making changes to obtain the 16 reparation measures that the sentence dictated. For example, now we have technical tables of technical jobs tables of health, of land, education and culture, and we have already changed the life of the community and the grandmothers of the abuelas. Now the community has a little clinic, mobile clinic, and with two persons who attend primary health. Is nothing biggest, but before the sentence, before the monitoring of MTM, before the interinstitutional space, Sepur Zarco didn't have nothing, and now they have something better. They have a cultural promoter. They have something that before they didn't have. And I have to finish. Thank you.
Thank you very much, Anna. Thank you very much. The last question is for you, Susanna, and it's really, if you want, about how can we take this work forward? How can this work, particularly the case of Sepur Zarco, which is really, as you mentioned, there were a number of innovative and important factors that went into it. How can we take it forward in the judicial and future judicial processes? How can external actors help, such as the team of experts and or donors and so on? Linked to that, because we have actually a question on the chat from the chat. If you can, there is a question about transgenerational victims, the people who actually, the survivors, people and the future generation. How can they actually take justice forward on the basis of your experience? Thank you very much.
Thank you, Mona, and all the panelists so far for the great discussion. I'm going to start with your second question because I think it actually ties into what Ana Medina was talking about. I think a pause to reflect on the incredible demand that victims made in this case, affecting not only the abuelas, but future generations, right? They requested not just compensation, but what are known as, transformative reparations to address fully the harms committed not just to the abuelas, but to the members of the community. And what's really remarkable here, and I think this is one of the lessons for other cases, is creativity and persistence of the victims and their representatives. So in this case, the Code of Criminal Procedure seemed to limit reparations to the perpetrators of a crime. But that did not deter the abuelas or their representatives, right? They argued, interestingly, that issuing measures against the state or state agencies was justified because those measures concerned constitutional rights owed to the victims that could only be protected and ensured by the state. So, I'm not sure this argument in particular would work in every other jurisdiction, but their creativity, their persuasiveness worked in this case. And the victims, as you just heard from Ana, started, even before the verdict became final, to try to implement, to try to gather the state agency representatives into mesas de trabajo, working tables, right, to implement those reparations. And that is extraordinary and has an impact intergenerationally. With respect to the other strategies, and how they could be used in future litigation, I think a number of them that I talked about and that I write about in the article with, I should say, Claudia Martin, my co-author there, can and should be brought to bear in other sexual violence and gender violence cases. But let me just focus on two of those strategies by applying them to another situation in the region, the conflict in El Salvador. El Salvador has recently started a process of accountability for war crimes and crimes against humanity perpetrated during their armed conflict after the Supreme Court basically declared unconstitutional a blanket amnesty that had been adopted in the early 90s. As a result, a few criminal investigations have been opened by domestic courts to address these crimes and to identify and punish the perpetrators. One of the most notable cases is the El Mozote massacre case. And that case involved the extrajudicial execution of about 1,000 victims, half of whom were children. The evidence in that case increasingly shows that women and girls were raped before they were murdered. And although the domestic indictment includes aggravated rape as one of the crimes charged against the accused, the focus of the investigation has been more on the extrajudicial killings than on the sexual violence. So a few lessons learned from the Sepur Zarco case might raise the visibility of the issue of sexual violence in that case and help achieve justice for families of those victims. So first, even if the domestic criminal code does not explicitly include an international crimes provision, the domestic system may allow or even require the court to use customary international law, binding on states in its interpretation of domestic law provisions, right? That's what the investigative judge did in Sepur Zarco. Here, again, while the indictment includes sexual violence as the domestic crime of aggravated rape, the prosecution could argue that rape was recognized as a war crime under customary international law, binding on El Salvador, and should be recognized as such in the case. This would allow the prosecution to do what we've been talking about, to lay out the context of the conflict and how violence, including sexual violence, was used by the state as an intrinsic part of the military strategy to defeat those it perceived as its opponents. Second, and I have a please conclude, so I will very briefly say the prosecution, I would encourage the prosecution in other cases to draw liberally upon the expertise of various domestic and international experts. And I'll just say that, expertise on this issue, well, let me just step back. The sexual violence committed by the state in El Salvador was, like in Guatemala, until recently largely invisible. So expertise on that issue, on how sexual violence was used by the military, its impact on victims, how it can be characterized as a crime under international law, that may well be unfamiliar to many of the judges as well as prosecutors. So the use of expert testimony to address those issues will help bolster the credibility of victims, but also help the courts appropriately situate the sexual violence in the context of conflict and issue the types of reparations that Ana Medina just spoke about.
Thank you so much. I am always touched by how much Latin America actually is leading and continues to lead this quest for accountability. And I think it really gives us all, from all parts of the world, actually, a lot of hope about, that justice can be delayed, but maybe not denied. And women are standing up, and sexual violence is an international crime in particular context. Sexual violence constitutes international crimes, and we are all determined that this ends. The perpetrators are brought to justice. With this, so I thank you very much also for answering the questions and for expanding them to include the colleagues or the friends from the chat. Sorry, we couldn't really take more questions from the chat, because now we are really getting to the end of our meeting, and now we have to hear Ambassador Charlotte Steller, the ambassador of Sweden, who is actually she has a long career in Swedish Foreign Service, and she is joining us now from New York, where she currently serves as the head of department with the Swedish Permanent Mission to the United Nations. You heard a lot, Ambassador, from all the panelists today, and you come from a country really with a feminist foreign policy, which we are all very proud of as women here. What do you think? What are your takes from this webinar today?
Well, thank you, Mona. And first of all, I really want to thank the panelists for highlighting ways forward. And I also want to thank the team of experts for convening this meeting, but generally for your strong leadership on issues of conflict-related sexual violence. What I take away from this conversation today is that steps have been taken to hold perpetrators accountable, which and some very innovative, which show that there is a way of tackling widespread impunity. for this kind of violence, and we need this, obviously. I arrived in 2017, fled from neighboring Myanmar. Many fled, obviously, after suffering atrocious acts of sexual violence. To me, this was a reminder, if I ever needed one, that conflict-related sexual violence is not a fringe phenomenon, as it's sometimes made out to be, but often front and center of these conflict-related events. So it's just not recognized nor addressed to the extent it needs to be. So obviously for Sweden, addressing conflict-related sexual violence and gender-based violence is a core commitment. And in particular, we want to find ways of greater accountability in the most challenging context. And this is why we've also provided core funding to the team of experts since the launch 10 years ago. But as we try to understand conflict-related violence and how to address it, I think there are three areas that stand out as central: prevention, survival-centered approaches, and partnerships. And I think partnerships has really been underlined here by all the speakers. So there are no shortcuts to addressing conflict-related sexual violence, obviously. So preventive measures are really needed to address the deep and toxic relationship between gender, power, and violence. And these gender stereotypes and inequalities still impact the possibility of women reaching an influence at levels of policy. So these are deep-rooted issues, and this is one of the main reasons why Sweden decided to adopt, as you've already mentioned, the feminist foreign policy in 2015 to help change the attitudes and perspectives that are at the root of all this. And that's why we are also committed champions of women, peace and security. So in Colombia and Guatemala, Sweden has supported work towards building gender equal relations and also engaging in conversations about gender, mostly FARC soldiers on gender and masculinity related issues. Survival-centered approaches obviously are essential for ensuring justice and accountability mechanisms are based on the needs of survivors, and that survivors also get to define what success looks like. And a challenge I see within the UN is that sometimes survivors are categorized in broad monolithic terms, which risks losing the unique experiences of and needs of specific populations. So that's something we need to keep in mind. In Guatemala, Sweden supports efforts of the justice system as well as survivors of sexual violence, and we're happy to have contributed in a small way to the very first sentence of sexual slavery as a crime against humanity, which was championed or put forward by a national court system. But obviously, lots needs to be done. Partnerships then, strengthening the capacity to address conflict-related sexual violence does require strong collaboration between many different actors. And I think what we've seen, not least through the Swedish development SIDA, is that really it has to be grassroots actors have to be connected with local, national, regional, international levels, because they are the ones who know what will work in their communities. Again, in Colombia, we've been working, we've been contributing to many collaborations which have had this as its underlying principle. And also Swedish police have worked with Colombian police to strengthen investigation and response to domestic violence. So I wanted to come back to the feminist foreign policy, which really is striving towards a reality where people of all genders have the same power to shape society and their own lives. And this feminist foreign policy obviously was first championed by Minister Margot Wallström, who's the former foreign minister, but it's also carried forward with the same force by current foreign minister Ann Linde, and has in a way been a game changer for us, for Swedish policy, foreign policy at large. It's helped us put gender equality up front, not as an afterthought, and it has also provided leadership from the top to bring accountability throughout the foreign service and beyond to better walk the talk on gender equality. So obviously, we are the victim, they must not be left behind. Thank you for inviting me. I've learned a lot, certainly, from today's exchange with the panelists, and I'm sure other listeners have as well. Thank you.
Thank you, Ambassador. It's really important to have you with us and your very wise words about really standing for states standing also behind this initiative, and really for the support for the team of experts all these years that Sweden really has shown. I would like to thank all this. We are almost at the end, or we are at the end of our actually webinar. I'd like to thank all our panelists and speakers who joined us today. And I would like to particularly thank our partners who made this possible and this webinar possible. The Harvard Humanitarian Initiative, the Carr Center for Human Rights Policy, for hosting us and hosting this session. It's really has been a wonderful session. We learned, I think, all of us a lot. I learned a lot from reading the papers. I really recommend the special issue. I highly recommend it to you. And you will have a recording of this. You will see it. You have it online on YouTube and on the webpage of the team of experts shortly. We will be continuing the series, so stay tuned, and we will have more. I think the next session will be in October, and we'll address challenges concerning the promotion of accountability committed in the context of terrorism. Very important and very timely issue. So stay tuned for that, and I hope all of you and more of you will join in that session. Thank you again, Ambassador, and thank you for the panelists for everything, for your statements, for your patience, for really responding to the questions, and for you, the audience, our dear audience, for being with us today. We hope you will join us in the future. Bye-bye for now.
Thank you.